You've probably heard the saying, the devil is in the details. Today, we're going to dive into a legal case where those details, down to how a single sentence was phrased in court, dramatically altered the course of justice for a family.
It's quite something.
We're talking about a fascinating and, well, frankly, quite intricate legal case from the Court of Appeal of Seychelles. It starts with a pedestrian accident or really tragic loss, but it quickly becomes this sort of masterclass in how legal procedures, the burden of proof, and even disagreements among judges can send what seems like a clear-cut case spinning into unexpected directions.
Absolutely.
We'll explore why every single word in a legal document matters and, how different interpretations of the law can lead to wildly different outcomes.
And this deep dive isn't just about one specific accident. It's more like a forensic look at how seemingly minor legal details like a single word in a denial or an outdated law cited by mistake can potentially derail justice. It really shows us that the battlefield of law often lies not just in the big dramatic facts, but in the meticulous, careful application of procedural rules and legal principles. So for you, the listener, this is a real opportunity to understand the foundational rules that govern how justice is pursued and delivered, even when those rules themselves become the heart of the dispute.
So what's our mission today? We're going to unpack the case of Rakoto Simbola and Rahajarevo v. Sainon, a recent judgment from August 2025. We'll trace its dramatic journey from a trial court's dismissal all the way to an appellate court's deep scrutiny.
Yeah, digging into the details.
Exactly, revealing the surprising intricacies of strict liability, the immense power of properly pleading your case, which sounds technical but is crucial and a truly compelling debate among the appellate judges over admitting a criminal conviction in a civil trial. As we delve deeper, I think you'll find some surprising twists that might make you rethink how the law actually operates day to day.
Okay, let's get into it.
Right. Let's set the scene for this legal drama. Our story begins with a tragic incident in Seychelles. A motor vehicle driven by a Mr. Ivan Sainon strikes Mr. Apollinaire Rahajarevo, who was a pedestrian. And sadly, the collision proves fatal for Mr. Rahajarevo.
Yes, and following this devastating event, the deceased widow, Mrs. Nandrandrena Rakoto Simbola, along with their minor son, Philip Rahajarevo, they initiated a civil claim.
Okay.
They were seeking 1 million Seychelles rupees, that's roughly $70,000 USD, in damages for the immense loss and suffering they endured. Their claim really hinged on establishing Mr. Sainon's liability for the accident.
Now, here's where the initial twists start coming in. The trial court, after hearing the case, actually dismissed their claim.
Just threw it out.
Right. And this decision immediately raised eyebrows at the appellate level, not just for the outcome, but for the reasoning behind it. The Court of Appeal later described the trial judge's rationale as, and this is a quote, regrettably opaque.
Opaque, meaning unclear, hard to understand.
Exactly. It lacked proper explanation. It was more of a perfunctory assertion, as they put it, rather than a well-reasoned legal argument.
And adding to this sort of lack of clarity, the trial judge made a critical error right at the foundation of the judgment. They cited Section 1383(2) of the old Civil Code.
Old code.
Yes, the problem was that specific section had been repealed. It was replaced by Article 1388 of the Civil Code Act of 2020, which had been in force since July 2021. So the very legal bedrock of the judgment was, outdated.
Wow. That's more than just a typo, isn't it? What happens when the law cited is simply wrong?
Well, it's a fundamental misstep. When the legal provision that forms the basis of a judgment is incorrect, it immediately calls into question the entire application of the law in that case.
Right.
The appellate court, which is usually a panel of senior judges, then has a clear duty to scrutinize how this error impacted the decision and, crucially, whether it led to a miscarriage of justice.
Yeah.
It signals that the trial wasn't just about the facts presented, but about the very legal principles being applied or misapplied in this instance.
Okay, so that flawed foundation sets the stage for the appeal. The appeal against this initial dismissal brought up several key issues, but one of the most critical revolved around something fundamental to any legal process: pleadings.
Ah, yes, pleadings.
For those of us outside the legal world, pleadings are like the bedrock of any lawsuit, right? They're the formal written statements where each side lays out their claims and defenses. Think of it like drawing up the battle lines, clearly stating your case for everyone involved to see.
Exactly. And the Seychelles Code of Civil Procedure, specifically Section 75, is quite precise on this. It demands that a statement of defense must contain a clear and distinct statement of the material facts the defendant relies on. A simple, no, I didn't do it, just isn't enough.
Okay.
And here's the crucial part, a procedural rule with potentially enormous consequences. Material facts alleged in the initial claim that's called the plaint. The documents starting the lawsuit must be distinctly denied. If they aren't specifically denied, they will be taken to be admitted.
So silence is consent, basically.
In this legal context, yes. Silence, or rather, failure to deny specifically, equals admission.
So what did the defendant, Mr. Sion, actually do in this case regarding his pleadings?
Well, his defense was described as a general denial. He only specifically denied 2 paragraphs out of the many in the appellant's claim.
Only 2.
Yes. And the critical failing, as the Court of Appeal highlighted, was that he failed to deny several specific and, frankly, quite damning allegations. These included things like he failed to adhere to road traffic rules, grossly neglected to notice himself of the pedestrians, and failed in all circumstances of the case to follow the road traffic rules and breach the basic essential duties as a driver. These were core allegations of negligence.
So he basically just sidestepped those key points and the legal effect of that oversight. What did the Court of Appeal say?
Well, according to the Court of Appeal, his failure to distinctly deny those key allegations constituted a binding admission of those facts.
Binding admission, wow.
Exactly. This principle, that what's not denied is admitted, is deeply embedded in Seychelles law. It emphasizes that parties have to meticulously plead all material facts they intend to rely on. You simply cannot introduce evidence on unpleaded facts later on, even if the other side doesn't object during the trial itself. This foundational aspect of legal procedure ensures that both parties and the court clearly know the case they have to meet right from the outset. It's designed to prevent what's sometimes called trial by ambush.
So this procedural rule makes it crystal clear that in litigation, silence isn't golden. It's basically a concession. It powerfully underscores why every single assertion needs to be meticulously addressed. But I'm curious, does this strict interpretation of pleadings ever lead to situations where maybe a defendant, perhaps someone representing themselves or less experienced legally, is unfairly disadvantaged by a technical drafting error?
That's a really vital question.
Yeah.
And the answer is, it can. While the rules are designed for clarity and fairness, ensuring both sides know the game, they can indeed pose challenges for self-represented litigants or those with less legal expertise.
Right.
The courts constantly grapple with this tension, balancing the strict adherence to procedure, which promotes efficiency and predictability, with the broader principle of ensuring access to justice and preventing substantive claims from being dismissed on purely technical grounds. It's a balancing act you see in courts worldwide, really.
That's a fascinating layer to consider. Okay, so with the technical battle over what was written down in court, let's turn to an even more fundamental question about responsibility. How does the law assign fault when a vehicle causes a tragedy like this one?
Yeah.
This brings us to the concept of strict liability in motor vehicle accidents, which is governed by Article 1388 of the Civil Code of 2020 in Seychelles. And this is like a real game changer compared to traditional fault-based systems where you have to prove specific negligence, right?
Indeed, it is a game changer. Under Article 1388, if a motor vehicle, by reason of its operation, causes harm, the driver is presumed to be liable.
Presumed liable, so automatic assumption of fault.
Essentially, yes.
Yeah.
It dramatically shifts the burden of proof. The injured party in this case, the family of Mr. Rahajar of Vornalina, doesn't have to launch some exhaustive investigation to prove the driver was negligent. Instead, the driver starts in a position of presumed fault. This isn't just a shifted burden. The court called it a statutory duty for the driver to prove otherwise. The policy thinking behind such a law often aims to protect vulnerable road users like pedestrians and ensure a clearer, maybe faster path to compensation.
So how does a driver possibly escape this automatic presumption of fault? It sounds like a very, very heavy burden to carry.
It is a very high bar. The law says the driver must conclusively demonstrate, which means, prove beyond reasonable doubt that the harm was solely or partly due to the fault or act of the injured party, or maybe a third party, or due to an act external to the vehicle's operation.
An act external? What's that?
That external act is what's known in law as cas fortuit. Think of cas fortuit as an unforeseeable, uncontrollable event beyond the driver's control, like maybe a sudden, unpreventable natural disaster affecting the road, or perhaps a sudden medical emergency that renders the driver incapable, or maybe a rogue animal leaping onto the road with absolutely no time to react.
Okay.
But importantly, the law specifies that vehicle defects or mechanical failures are not considered cas fortuit. Why? Because a driver is expected to maintain their vehicle in good working order.
Right, that makes sense. And in Mr. Sinon's case, the appellate court found that the trial judge fundamentally misapplied this strict liability principle.
Yes, they did. Instead of demanding this affirmative proof of exoneration from Mr. Sinon, the trial judge seemed to accept what were essentially unsubstantiated assertions.
Just his word for it.
Pretty much. This allowed Mr. Sinon to potentially escape responsibility through what the appellate court called vague allegations rather than compelling evidence. And this misapplication meant that for Mrs. Rakatoa-Sambola and her son, the very law designed to offer a clearer path to compensation was effectively turned on its head at the trial level.
So what kind of evidence was lacking from Mr. Sinon, according to the appellate court?
Well, the appellate court looked at the trial record and pointed out a stark lack of corroborating evidence from Mr. Sinon. He produced no independent witnesses to back up his account of the accident.
No witness.
None independent. No expert testimony on, say, road conditions or his reaction times. And crucially, no objective physical evidence like skid marks or maybe CCTV footage if it existed. His own testimony was characterized by the appellate court as inconsistent and ambiguous, falling far short of the rigorous standard needed to rebut that strict liability presumption. So it wasn't really a case of conflicting evidence. It was more a case of insufficient evidence from the defendant to meet his legal burden under Article 1388.
And what about the idea of the pedestrian's contributory negligence? You know, the possibility that the deceased might have also been partly at fault. Could that have been an escape route for the driver?
Contributory negligence can reduce a driver's liability? Potentially, yes. But again, the strict rules of pleading apply here too.
Back to pleadings.
Exactly. Contributory negligence must be expressly pleaded with particulars. You have to spell out exactly how the injured party was allegedly at fault. Mr. Sinon's defense included a general denial that the deceased crossed without negligently or care and attention. The court noted the grammatical issue there, but was deemed grammatically incoherent, equivocal, and insufficient.
Not specific enough.
Not nearly specific enough. Because it wasn't properly pleaded with the necessary details, the trial judge technically shouldn't have even allowed evidence on that issue. It just reinforces the point. Strict liability demands compelling, well-pleaded evidence from the driver, not mere allegations or vague suggestions. The system is really designed to prevent a driver from just pointing fingers without a clearly articulated and supported case for why they shouldn't be held responsible.
This truly highlights the incredible weight of this strict liability regime on drivers, and again, how every word in a legal document or the lack thereof can dramatically shift a case. But the narrative takes another sharp turn here, doesn't it? With a truly fascinating legal debate. The admissibility of a criminal conviction in a civil trial.
Yes, this has another whole layer of complexity.
The appellant's initial claim, the plaint, mentioned that Mr. Sinon had been charged by the Attorney General's office for causing death by dangerous driving. And the respondent, Mr. Sinon, actually admitted this averment in his defense. He admitted he'd been charged.
That's right. However, here's the timing issue. The criminal trial wasn't concluded when the civil plaint was filed. It concluded after the civil plaint was filed, but before the civil case was actually heard in court. And Mr. Sinon was convicted of the criminal charge.
Okay, so convicted after the civil case started, but before it went to trial.
Precisely. So during the subsequent civil trial, the appellants, the family, sought to introduce this criminal conviction as evidence against Mr. Sinon, specifically when they were cross-examining him.
Makes sense, you'd think, but the trial judge excluded it. What was the reasoning there?
The trial judge's reasoning was that while the charge had been pleaded, mentioned in the initial documents, the conviction itself was a new factual development that hadn't been specifically pleaded. Therefore, it couldn't be introduced. It sounds like another instance of procedure potentially blocking crucial evidence.
Another technicality.
Seemingly. But this brings us crashing into Section 29 of the Seychelles Evidence Act, which is a really crucial piece of legislation in this whole debate.
Okay, Section 29, what does it say?
It explicitly states that a criminal conviction is admissible in a civil trial, with some exceptions, like defamation cases, which aren't relevant here specifically to prove that the person committed the offense they were convicted of.
So the law says it's admissible.
Not only admissible, but Section 29 goes further. It creates a rebuttable presumption that the convicted person did commit the offense unless they can prove otherwise in the civil trial. So, on the face of it, the law seems quite clear that the conviction should have been allowed in.
So, what did the appellate court decide on this point, given that clear wording in Section 29? It seems like the trial judge ignored the statute.
Well, Dr. Twomey Woods, who was a justice of appeal and wrote the leading judgment for the majority, found the exclusion of the conviction to be an error. She argued that pleading the charge was sufficient notice to Mr. Sinan. Her view was that the modern approach to pleadings should be pragmatic, practical, avoiding unnecessary formalism or it would lead to an unjust result. She stated there was no prejudice to the respondent, no unfairness to Mr. Sinan, since he was obviously well aware of the criminal proceedings and their outcome, the conviction.
Her argument was basically, don't let hyper-technical procedural rules block relevant evidence, especially when the other party clearly knows about it anyway.
That seems to be the essence of it, yes. Yep. Substance over form, perhaps.
But this wasn't a unanimous view among the three appellate judges, was it? This is where it gets particularly interesting because it really shows the different philosophical approaches to legal interpretation bubbling up.
Not at all unanimous. And this is truly illuminating for you, the listener, to see how highly qualified legal minds can grapple with the same set of facts and the same laws and come to different conclusions. Justice Robinson, also Justice of Appeal, agreed with Dr. Twomey Woods on the main issue of liability.
Okay, so she agreed Sinan was liable.
Yes, but she dissented on this specific point about the conviction's admissibility.
Why?
She argued that even with Section 29 saying convictions are admissible, the initial plaint must still contain specific particulars about that conviction, like which court, the exact type of conviction, and its relevance to the civil case as required by a different rule, Section 71 of the Civil Procedure Code.
Ah, another procedural rule.
Exactly. Since these crucial details about the conviction, not just the charge, were missing from the appellant's pleading, she concluded the trial judge was actually correct to exclude it, despite Section 29. Her stance was firmly rooted in strict adherence to procedure, believing that for basic fairness, all the key details must be laid out formally in advance.
Okay, so one judge says Section 29 trumps procedure, another says procedure dictates how Section 29 evidence comes in. What about the third judge?
Justice Andre, the third Justice of Appeal, who actually dissented on the overall outcome of the appeal, also had a different take on the conviction issue, adding yet another layer of complexity.
Right. What was her view?
Well, Andre J.A. agreed that the trial judge's reasoning for excluding the conviction, the reason given, that it wasn't pleaded, was technically flawed because of Section 29.
So she agreed Section 29 applied?
Yes, but she ultimately upheld the result of excluding the evidence. However, she did it on a completely different ground. Procedural unfairness.
Unfairness? How so?
She argued that allowing the appellants to suddenly cross-examine Mr. Sinan on a conviction that happened after the initial pleadings were filed, without him having formal notice through amended pleadings, or sufficient time to prepare to rebut that presumption from Section 29 would have been an unfair surprise.
Okay.
This, she felt, was inconsistent with fundamental fair trial principles.